Now we can start.
November 5th, 2025, the advisory group of experts has gathered in full force to interview the candidate for the position of judge of the Constitutional Court of Ukraine, Yana Lenher. Specifically, all 6 members of the advisory group of experts are present. The advisory group member, Hanna Sokoska, the members Alice Zoller, Yaroslav Romanuk, and Vasil Shakun, as well as myself, the Secretary, Maureen O'Connor. I would like to note that our member, our chair, Oksana Valsachenko, recused herself from the interview of the candidate. Therefore, in accordance with the law of Ukraine on the Constitutional Court of Ukraine and the regulations for the advisory group of experts, Deputy Advisory Group member Vitaly Makinchuk, who is also present, is exercising the powers of an advisory group of expert member with regard to the evaluation of this candidate. The other deputy members who are present are Thomas Griffith, Richard Barrett, Marek Zubik, and Vladimir Kuzmenko. They are present during this interview. I would also like to note that we are working, that the interview is taking place in a shelter, so that in the event of an air raid alarm, the interview will continue without interruption. I'd also like to remind you that the interview is being recorded and broadcast live on the Advisory Group of Experts resource and the Constitutional Court of Ukraine website. Therefore, I would like to draw the attention of the members of the advisory group of experts and the candidate to the restrictions on the use of sensitive data and information with limited access during the live broadcast, if necessary. The advisory group of experts will restrict the broadcast for the time being in order to discuss such issues. We are ready to begin. I'd like to remind you that in the interview, that the interview is part of the candidate's assessment stage to determine their compliance with the criterion of high moral character. As before, each interview will last approximately 1 hour, and the time limit for answering the questions is 3 minutes. Traditionally, we ask all candidates to be concise and to answer the question clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a brief closing statement of up to 5 minutes. I'd also like to note that while reviewing the materials on the candidate was sent questions for written explanations, so the candidate has had the opportunity to prepare and to provide answers. So I will now briefly introduce our candidate. She is a doctor of law, professor, and specialist in constitutional and municipal law. She has over 21 years of professional experience in the field of law and many years of experience in scientific and pedagogical activities, including department management. Since October 2023, she has been working as a professor in the Department of Constitutional, Administrative, and International Law as the Faculty of Law of Lechia Ukraina Volyn National University. Ms. Lenher, if you would like to add anything to the introduction that I just made, you may do so within 3 minutes.
Дуже дякую. Всі дані наведені вірно.
Thank you very much indeed. This introduction is right. Thank you.
Questioning, Mr. Romanuk.
Дякую, пані Оконор. Шановна Яна Іванівна, дорадча група.
Dear Yana, the advisory group of experts presumes that all candidates for the position of the Judge of the Constitutional Court of Ukraine, by definition, possess integrity. And also you, in your motivation letter, mentioned that you have impeccable reputation. At the same time, if in the process of review of the candidacy, the advisory group of experts have any doubts about integrity, we give the opportunity for the candidate to disprove such doubts. Madam Connor already discussed that you have actively communicated with the advisory group of experts and gave the answers to the questions that we had in the process of review of your candidacy, for which we are grateful. At the same time, still we have certain things that we would like to clarify today during the interview. So, in June of this year, you have purchased within the e-housing program the flat in the apartment in the suburbs of the city of Lutsk. And you made the first payment, the down payment, which is the equivalent of 10,000 euro. You explained that the funds for making this down payment have been provided by your mother, who is working in the Czech Republic. Could you please tell me, do you have any documentary proof that your mother has earned in Czech Republic this amount of money? Thank you for this question. As I communicated with experts of the advisory group, I provided the certificate of the income of my mother. It is officially confirmed. She is officially employed. According to the national legislation, when taking into the territory of Ukraine the amount of 10,000 euro or more, or exporting from the country, it's necessary to declare this amount of cash. Do you have documentary proof that such money have been legally imported in the territory of Ukraine by your mother or a trustee? My mother did not declare, and my mother brought it in fragments because it was earned and imported into Ukraine in fragments rather than the lump sum. Your father is a person who is authorized to carry out the functions of the state. Like other persons of such a status, he is obliged to file a declaration, which he regularly does. Inter alia, in this declaration, he has to represent the income of the members of his family. In our case, your mother, who is his wife. Analysis of the declaration of your father demonstrates that he did not represent such an income of your mother in Czech Republic, which she gave to you to buy the apartment under the e-housing program. What would be your comment? My father simply did not know. The declarant cannot declare this, the income he is not aware of, because he cannot have the access to it. Even without this request from the expert, he would never know of my mother's savings. So the husband is not aware of the income of his wife. In this case, no. And yet you have documentary proof that such income took place, and at the expense of such income, you made the down payment. Thank you. Since 2010, you own another apartment in the city of Uzhgorod on the grounds of joint ownership. What was the grounds of acquiring such ownership, like a purchase and sale agreement, inheritance, or the gift agreement? Purchasing the flat under mortgage agreements with the fund of use, how it was joint ownership. Who is another co-owner or co-owners? Since 2023, the other co-owners are my children, Sofia and Andrei. In the beginning of the purchasing, we had 4 co-owners, myself, my former husband, and 2 children of us. Then, after the divorce and dividing the property, we had joint ownership. Since the time of purchasing of this apartment, how it has been used. We have lived there, we have been living there. Until what time? We have lived there until the moment when I moved to Lutsk city in 2019 together with my children. Since 2019, how this apartment has been used? It's not used. It's unused. Since the year 2019, it was in joint common ownership. And the co-owners alone could not dispose of with no consent of another owner. And we did not do it because my former husband, since 2019, this apartment is empty. In 2023, we have divided it by the agreement of dividing the common property. Especially after the beginning of the war, this apartment has high liquidity. and it could be rented out. Did not you use such opportunity? No, we didn't, because we lived together with children first half an hour, half a year. You said 2019. Yet, with the beginning of the war, we have been there for 3 months. In the beginning of the sharp phase of the war, from February to April of 2022, over all this time since purchasing this apartment, it was never rented out. No. And what about now? Now the agreement was signed with the real estate agency, and it will be rented out. There is the announcement since August in the open access, but there are no tenants so far. I don't have any other questions. I give the floor to my colleague, Marina Connor.
Thank you. I'm now going to ask you some questions regarding your role as a scientific opponent of the former Ukrainian parliamentary minister Derkash, who is suspected of treason and is currently a senator in the Russian Federation. You are familiar with who I'm speaking?
Я познайомилася з ним в День захисту.
I met him on the day of defending the thesis. Neither before nor after I did not have any communications.
2019, you participated as an official scientific opponent in the defense of the dissertation for the degree of Doctor of Law by People's Deputy Derkash. The topic of the dissertation research was protection of human rights in the constitutional process, issues of theory and practice. That was in 2023, the Security Service of Ukraine exposed an agent network of the main intelligence directorate of the Russian Federation, which included the People's Deputy of Ukraine, Derkash. His former assistant confirmed that he had been recruited by Russian special services since at least 2016. He is currently a Russian senator and a member of the Russian Federation Council Committee on Security and Defense. In response to the questions from the advisory group, you confirmed that your work as an opponent for this dissertation was not paid for, and that you did not receive any other benefits, and that you stated that none of your expenses were covered. Is that accurate?
Так, інформація.
Yes, this is true.
Okay. You also noted that you met the candidate directly at the defense and had no personal communication with him prior to that. And that is also accurate, correct?
Так.
Yes.
All right. Did you have any contact, communication, or meetings with him after the defense in any form, whether by person or phone, by mail, email, through intermediaries, in any way?
Ніяким чином.
No, by no means.
That you lived in Lutsk and the defense took place in Kiev, please clarify who paid for your travel, your accommodations, your meals, or other expenses related to the trip for this defense.
The bus tickets, I traveled back and forth on the same day, and I paid myself. I did not use any lodging because I did not travel before.
And there were no payments. Now, this also includes any informal compensation. You say that you paid for your own transportation. There was no hotel used. You did not receive a per diem or any gifts or symbolic rewards or coverage of expenses by even a third party. Are those accurate statements?
Так.
Yes.
Has established a connection between Mr. Derkash and the Russian Special Services since at least 2016. Can you confirm that at the time of your participation in his defense, you had no information or indications that could indicate a potential danger, questionable reputation, or possible influence of third-party interest on the scientific process.
Ні.
No.
Right. Now, I'm going to ask you some questions about the use of scientific conclusions of the scientist Lata. When preparing your dissertation for the degree of candidate of science on the topic Reforming the Legal System as a Means of Improving Its Effectiveness, 2007, you stated in subsection 3.1 of section 3 as your own conclusion. There is a series of paragraphs that correspond in that document to previously formulated conclusions by the scientist Lata in her dissertation for the degree of candidate of legal sciences on the topic Administrative and Legal Regulation of Rulemaking Activities of Executive Authorities. And without going into reading all of the similarities and the exact wording, you have represented without attribution to scientist Lata significant sections of your document. And how would you explain that?
На дисертаційне дослідження
Thank you. As for dissertation for the thesis of the candidate of legal sciences, there is a reference in the list of literature, and there are coincidences in the conclusions to the subsection. As for the entire chapter, there is no reference because it's a summarization of information of all the chapters.
Classify your use of that information as common information that is known by people in the field without the necessity of attribution? Would that be a fair assessment of your justification?
так, тому що
Yes, because this is general theoretical information, and partially we also learned it when we studied the theory of the state and law. The notion of legal norm, types of legal norm, and the norm creating development process.
Placed in your article and that of the scientist Lata, some of it appears to be word for word identical or extremely similar. And you're saying that is permissible?
ні, це не дозволяється.
No, this is not permissible. However, when the thesis is written, the scientist is working on a number of literature, theoretical and practical, depending on the subject matter of the research. And there are some well-known statements which are remembered, and one uses them with no reference, like notion of the norm, the government agency, local government. There is a reference in the list of literature, and her work has research is mentioned in the list of literature among the sources which were used.
You stated that the borrowed text was not formatted as a quotation or to paraphrase with an accurate reference due to your mistake. You insisted that the conclusions to the subsection do not necessarily contain unique or author's conclusion, but only show, as you said earlier, the logical completeness of the subsection. Therefore, this fragment cannot be regarded as your own conclusion. So, what is it? Is it a mistake on your part and you should have attributed it, or it was not necessary?
2007, whereas I was writing dissertation paper, there were no such rigid requirements on quotations and referring to all borrowed paragraphs. You can consider this as my mistake if we take into account the situation that is right now in our days with the new requirements.
These requirements of attributing or attribution to the original document authored by someone else is now the requirement, but was not the requirement back in 2007.
Ні, це не нова вимога, це
No, it's not the new requirement. All scientists have to, as they use the text of other scientists, they have to refer or give attribute to other scholars.
That was always the case. It's nothing new.
так.
Yes. These are moral, ethical norms of scientific research.
I guess I need clarification. Are you justifying that you did this and it was okay to do? Or are you saying you should have known better and you should have attributed it to the other scientist?
Ні, це
No, this is not okay, but with the generalization of the text publicly quoted in the chapter, there could have been a mistake in this particular subpoint of summary.
You will admit that there are significant passages and parts of the dissertation that are almost verbatim.
якщо текст був
If the text was borrowed, then yes.
That was a significant portion.
я направду
I don't really remember my dissertation paper. This was long time ago.
I understand. Was that your only dissertation?
ну, ще є докторська.
There is a doctor's paper to receive the Doctor of Legal Sciences.
All right, given the very high degree of textual similarity between the excerpt from your dissertation and the work of scientist Stoyatina, identical wording, logic, and structure of thought, do you not think that in order to ensure the standards of honesty and integrity, it would be necessary to clearly indicate borrowing or explain the origin of such a coincidence?
Так, звичайно.
Yes, of course.
Agreement that you deviated from what would have been the ethical standards both now and previously in your use of the work product of other scientists. Okay. Okay, I'm going to draw your attention to the use of scientific sources from the Russian Federation. While writing your doctoral dissertation on the topic, Conflicts in Municipal Law, Problems of Theory and Practice, which was defended in 2017, you used dozens of Russian scientific sources. In other words, used Russian scientific sources after the Russian Federation had been engaged in armed aggression against Ukraine for 3 years, since 2014. In response to a question from the advisory group, you explained that in 2014 to 2017, when preparing scientific materials, the main criteria for selecting sources were scientific value and authority, as you use the works of leading scholars in the field of legal theory, who had made a recognized contribution to the development of the relevant subject area. Theoretical scientific sources were selected because they contained generalizations of general principles, methodological approaches, and conceptual models that allowed you to form an analytical basis for your dissertation and compare different approaches to categories and concepts. I believe you explained that at the time of your doctoral dissertation defense, the strategy for information security of Ukraine, which was approved by the decree of the President of Ukraine number 685-2021 of December 28, 21, and whose purpose is to take measure to deter and counter threats to the information security of Ukraine and neutralize information aggression, in particular to ensure the information resilience of society and the state. You stated that you used only dialogical sources of a theoretical nature to analyze the concept of legal norms and conflicts. Is that accurate?
Так.
Yes.
Given that your doctoral dissertation is predominantly theoretical in nature, and that the Russian Federation has been waging armed aggression against Ukraine since 2014, can you explain why you gave preference to Russian scientific sources in 2014 to 2017?
Там
The part of these scientific sources, not just textbooks, but there were monographies of theoretical experts of law. There are translated versions of law sources of Kant, Hegel. I didn't find at that time adequate, correct Ukrainian translation. Yes, that's correct.
Find that used Russian sources because that was the only option for describing the universal general theoretical legal categories. And that's not necessarily tied specifically to Russian interest. Is that accurate?
ні. Так, це ніякі
Yeah, no, it's not connected with the interests of Russia. It's connected with the publications and the available research base that I had at that moment.
Used, from what I understand, information that was formulated as far back as 2006, correct?
уточніть, яку.
Can you clarify the question? What information you're talking about? Excuse me.
2006, the bills considered by the government, 1/3 were rejected by the president. My point is that some of the documentation you used was created before the Russian aggression against Ukraine. So they were not prohibited when they were created prior to 2014 or 2012.
Excuse me, there's a technical problem, and the interpreter could not hear the last question. Just a second. The technical guys are trying to solve. Just a second. Could you please test, say something? We'll test the sound, please. Miss, can you hear us?
Can anybody hear me?
Yes, I do, but
Чутно.
Shall we try to continue?
Yeah, let's continue. That concludes the questions that I have regarding your dissertations and the creation of your documents. I'm not going to open it up to any other questions from any of our members of the advisory group of experts. Does anyone have a question? Okay,
Yana
if there
Lenher.
are no further questions, then I am going to ask
Є,
our
є
candidate.
запитання, є.
Yes, yes, we have questions.
Яна Іванівна, є три суб'єкти призначення
There are three subjects of the Constitutional Court: Verkhovna Rada, President, and courts and judges of Ukraine. You made your selection, your choice. You wanted to take part in the competition of the judges. So do you feel that you are the prominent and you are a very well-known legal expert in Ukraine? Have you taken part in different measures that took place in the judicial system regarding constitutional law? No. In the judicial system? No. Why have you made decision towards this subject of application? There are different competitions. This is the first competition I saw from this subject. This was June. It was announced in June. There are no other links, no other communications associated here. I don't have any questions. I have a question. Can you tell me, please, speaking about the dissertation of Derkach, who was the scientific consultant of this dissertation and who were the opponents? I don't remember, to be honest with you. I remember the secretary, Alexander Bykov, who invited me to be the opponent, and it was for the first time of my participation in the council. I can open this document. I can tell you the name if you give me permission. No, thanks. That's not needed. Any more questions? No.
Thank you, colleagues, for your questions. If there are no further questions, I'm going to ask the candidate to make a brief closing statement. As I mentioned earlier, up to 5 minutes, and then we will conclude the interview. So please proceed.
Дуже дякую.
Thank you very much. Thank you very much for your time. Thank you for the work and wonderful communication. I want to wish you a good day and good weekend. Thank you.
Thank you very much. We will now conclude this interview.